My learned brothers and sisters, this is Advocate P. Devmorari talking to you from Ahmedabad city, Gujarat state, India, that is our Bharat. Today I have selected a very good topic from criminal law, and that is dying declaration. In short, it is known as DD. Bharatiya Saksha Adhiniyam 2023, Section 26. And prior to that, Indian Evidence Act, Section 32, Subsection 1. Both deal with dying declaration. Now, what is called dying declaration? This is the first question to be answered. In cases of homicide, statements made by a person since disease are admissible to prove the cause and circumstances of man's death. Such statements are called dying declaration, that is DD. Such statements should be made when he was in settled, hopeless expectation of imminent death. A dying disposition comes on the record under Section 160 of BSA and not as a written statement made by a disease under Section 26 of BSA, that is 32 subsection 1 of Indian Evidence Act. Now, what are the conditions necessary for reception of dying declaration? When dying declaration can be received in evidence? Before the statement may be admitted, it must be proved that the person who made it is dead. So death is to be proved. And the burden of proving death is upon the person who wishes to prove the dying declaration. This is clear from Section 104 of Indian Evidence Act and at present Section 107 of BSA, that is Bharatiya Sakshi Adhiniyam. Illustration. He wishes to prove a dying declaration of B, then he must prove his death. The prosecution has to satisfy that the injury did not adversely affect the normal understanding or power of recollection of the dying man. Then he can give the dying declaration. It is valid. When a person who made the dying declaration has survived and has not been examined in the case, the court is prevented by law not to receive. It cannot be considered dying declaration because it's not examined by the court. Now, first information report, Section 173 of BNSS, Bharatiya Nagarik Suraksha Sanhita 2023, Section 173 talks about first information report. Previously, it was Criminal Procedure Code, Section 154. Where after making the first information report, the victim comes to his injuries, it can be treated as dying declaration and is admissible under Section 26 of BSA, Bharatiya Saksha Adhiniyam. Citation in 1976 SC 2199. The first information report against an accused is admissible under Section 26 BSA as a declaration as to the cause of informant's death. But if the complainant who had been beloved died a natural death and not because of the injuries caused, then Section 26 of BSA, BAS or Section 32 Evidence Act is not applicable. A fire cannot be used against the maker at the trial if he himself becomes an accused. The person who records a dying declaration must be satisfied that the deceased was in a fit state of mind and body. In 1972 SC 1776, the declaration should be taken down in the language in which it is made, using as far as possible the exact words of the declarant, and it is not a continuous statement but was elicited in answer to questions. The exact questions and answers should be noted. The dying declaration should be recorded in question and answer method. The court can judge why it should be recorded in question and answer method. The reason is the court can judge whether any leading question was put to elicit a certain answer. When the dying declaration is recorded in the language of the declarant, same acquires added strength and reliability, the most valuable. The statement of the deceased to the police is admissible as a dying declaration even if death took place much later. When the dying declaration made to the informant was not mentioned in the FIR, and the doctor's evidence is that the victim has survived only for 10 to 30 minutes after the attack, the evidence regarding the dying declaration is doubtful. When in a wife burning case, the dying declaration was recorded by the doctor and it was not attested by the persons present, it could not be relied upon. The dying declaration gave a very detailed and graphic narration of the entire history of the case, starting from the motive, enmity, and minute features of the assault, excluding the individual acts committed by the accused. It is impossible to believe that the deceased, even if conscious, would have made such a detailed statement. This statement smacks of concoction of falsification. Citation A 1981 SC 1578. Use of FR as substantive evidence is illegal. FR can never be used as substantive evidence. The statement of a deceased person is irrelevant unless the cause of death of the person making such statement comes into question. A dying declaration ought not to be admitted unless it is proved that the death of the declarant was caused or accelerated by the wounds inflicted by the accused, or that it was a transaction which resulted in his death. A man shortly after injury made a statement relating thereto, or later discharged from hospital, but died of fever after a few days, there being nothing to show that his death was due to injury inflicted. His statement is inadmissible. BSA Section 26, previously it was Section 32 Evidence Act, refers to actual cause of death or to the transaction resulting in death. If a woman is raped and commits suicide 3 days later by drowning herself, a statement by her to her mother-in-law immediately after the rape is not admissible. If the vital organ of the deceased were completely smashed, it is impossible that he was in a fit state of mind and body to give the detail. In 1983 SC 554, when the deceased was in a semi-conscious state, when he made the statement and he was talking incoherently, the possibility that his imagination might have played with him in giving out the names of assaultants cannot be ruled out. Citation 1983 CRLJ NOC 180 Calcutta Division Bench. Hope you have enjoyed this video. See you in the next video. If you are new to our video, please subscribe, like it, and share it. Thank you very much for patient hearing. Thank you very much for joining us. Thank you. Thank you.